United States has sent military forces into another country, struck targets near its capital, seized the sitting head of state, and flew him to New York to stand trial. You could be wondering, am I watching a Hollywood movie? Is this really going on in 2026? But some people might also be wondering, is this legal under international law and how someone can get away with this? Hi, and welcome to Hater Legal. I'm a lawyer based in Australia, and by the end of this video, you will have a solid understanding as to whether Donald Trump has breached international law by ordering US military action in Venezuela. So to understand this, you need to know the single most important rule in modern international law, and it comes from the UN Charter, and it's basically the global version of keep your hands to yourself. And that is Article 2 of the UN Charter. Article 2 basically states that countries are not allowed to use military force against other countries. Not most of the time, not unless they are allegedly hiding weapons of mass destruction or they're importing fentanyl into my country. Just not allowed at all. And that rule exists for a reason, because after World War II, the international community decided that letting big and powerful states attack weaker ones whenever they felt like they were justified was a terrible system, and it resulted in tens of millions of deaths. So in order to figure out whether there's been a breach in international law, we need to figure out first, has the US used force in Venezuela? And here the answer is not especially controversial. It's everywhere. You can see the footage. It's been published by the White House itself. Military strikes, special forces operating on the ground around Caracas, and the physical seizure of the head of state. Everything that is in the textbook for using force. So now that we accept that force was used, the burden now shifts to whether that force was justified. And there are really only three recognized legal justifications. The first, whether you've received authorization from the UN Security Council. This is an easy one to prove because it simply didn't happen. There was no Security Council resolution, and if anything, the US didn't even seriously consider asking the UN Security Council because they probably knew that it wouldn't pass through. So they didn't even bother raising it, because if doing so and then it was rejected, it probably would have looked worse on their behalf on the international level, but they probably don't even care anyway. So that brings us to our second consideration, and whether there was consent to come into the country. If the lawful government of Venezuela invited the US to intervene, that could potentially make the action legal. But here's the problem. The government that actually controls the territory, the armed forces, and the state institutions of Venezuela, they did not consent. And international law cares a lot about who has effective control, not who foreign governments would prefer to recognize. You can't bypass sovereignty just because you're declaring that the existing government is illegitimate and you pick a replacement who doesn't actually govern the country at the time. That is not how consent works in international law, because if that was the case, then every invasion would just be rebranded as, we were invited by the right people. And try and find me one country on earth where you could find every single person happy with their government. It doesn't exist. Anyway, this leaves us to the third and most commonly abused justification, and that is self-defense. Just picture here, Iraq, weapons of mass destruction. If we don't do anything, then Iraq is going to attack us. So we need to defend ourselves by invading another country. And yes, under international law, a country does have the right to use force in self-defense if it suffers an armed attack. But it can't just be a vague threat. It can't be criminal activity. It needs to be an armed attack. And even then, the response needs to be necessary. It needs to be proportionate to the threat towards you. And this is where the legal case in the US gets quite thin. And that's because the justification wasn't that Venezuela launched an armed attack at the United States. It wasn't even that one was imminent or one was coming or that they were going to be attacked. Instead, they argued that Venezuela's leadership is involved in drug trafficking, narcotics, and that in turn was harming Americans, US citizens, and therefore this is a form of self-defense. Now, drug trafficking, however serious, has never been accepted as an armed attack, and it doesn't give the person a right to military self-defense against another state. If that was the case, then any country could justify invading another country by pointing towards organized crime or cybercrime, or somebody hacked our systems in our country, or any kind of cross-border criminal activity. And that's what exactly the UN Charter was designed to prevent. It was designed to prevent these sorts of escalations. There's also the attempt to frame this as a law enforcement operation because there was criminal activity overseas. But international law doesn't care about what label you put on it. It looks at the scale, the location, the targets, and all of the context around it. So even if you brand it as a law enforcement exercise, it doesn't necessarily mean that it's going to be interpreted that way. Now, all of this leads to a much heavier legal concept, and that is the crime of aggression. And after World War II, aggression was described as the supreme international crime because it contains the accumulation of everything that follows. Once you start becoming aggressive, and then there's all sorts of events that follow that, then it's a result of that initial aggression. And so that's why it's considered as one of the most serious violations a state can commit. Whether anyone could realistically prosecute a US president for aggression, that's a completely different question. And I can probably answer that now. I don't see that happening anytime soon. The US has a veto at the Security Council, and international courts have limited jurisdiction over powerful non-consenting states. And the US can simply turn its back and say, we're not listening to any orders that are coming from here. So in order to kind of avoid that embarrassment and shame, it's unlikely that anything will actually happen in the first place. The problem with international law is a powerful country can violate it and still avoid punishment. But that doesn't magically make the actions lawful. It just means that we live in a system that isn't perfect. And here's an important point. International law survives based on how other states react. If other countries treat this as an illegal action, if they condemn it, if they refuse to normalize it, if they maybe put embargoes in place, then international law becomes something meaningful. But if they simply ignore it, shrug their shoulders, move on because they're scared of any potential ramifications, then all of these principles and the system starts to erode. This isn't just about Trump. It's not just about USA. It's about whether the basic rule against military force still means anything in 2026. So, bottom line, based on the facts publicly reported, the legal framework of the UN Charter, and the consensus of mainstream international law experts, this operation is extremely difficult to justify as lawful. There was no Security Council authorization, no valid consent from the state, and no credible self-defense claim tied to an armed attack. And that means it is a breach of international law. Now, whether anything happens because of that, that's a completely different story. If you've got any questions, drop them in the comments. And if you found this video to be useful, please like and subscribe to the channel because it tells the algorithm that people actually take international law seriously. I'll see you next time.